Everyone has the right to wear whatever they want to. However, this right will have certain restrictions. Now, at certain religious places, educational institutions, or public places, there might be some restrictions that might be put onto you. Now, in a similar manner, another case has come out wherein the Allahabad High Court that is there, it has rejected a school girl's plea to wear hijab along with the school uniform. Now, in this video, we will examine as to the rights of wearing what you want, under which fundamental right is it covered, and to what extent is it covered, and what has been the Supreme Court's judgment with respect to the right to wear hijab along with uniform, and what Allahabad Court has said, and why it has said so. All this and much more is what we are going to discuss in this video. So let's get started. First of all, what is the news all about? It is about the Allahabad High Court, which has rejected the plea of a schoolgirl. She wanted to wear a headscarf, or you may call it as a hijab, along with the prescribed uniform of that school. However, the court rejected this plea, and the court held that the past non-enforcement. Previously, there have been cases wherein the school uniform was not completely enforced and people were allowed to wear hijab as well. However, the Allahabad High Court this time around is saying that the past non-enforcement of the dress code does not mean that it is permanently non-enforceable every time, all the time. And in this particular instance, we are not going to accept the plea. Right. So let us understand what reasoning is the court giving, and what questions does this judgment raise, and what can be the way forward. Before we move ahead, an important announcement with respect to the new batches that are starting at Legacy IS Academy, with each batch having a size of only 40 aspirants, in order to have a personalized attention to each and every aspirant for their studies for UPSC. New batches, that is regular batches. The next batch is going to start in September, and then in November we have the weekend batch as well, which is specifically designed for the college going aspirants or the working professionals. That batch, weekend batch, is going to start from 10th of October. Once you enroll with Legacy IS Academy, there are a lot of benefits that you will have over others. Some of them are listed here. Very first, comprehensive coverage of the syllabus, but the game changer can be one-on-one mentorship, doubt solving, and regular interaction with the educators that you just saw. Maximum size is only of 40 students. There will be daily mains answer writing practice. At the same time, test series for both prelims and mains will be there in order to ensure that Legacy IS Academy becomes one-stop solution for all your UPSC needs. In addition to this, we have a 360-degree approach for current affairs, wherein the entire week's current affairs is covered subject wise and in an prelims and mains integrated manner. So if you want to enroll with us, you can simply download the app, or you can simply log on to the website or call the numbers that are given over here. Now let's continue with the news. So what are the questions what questions does this judgment raise? It raises the questions with respect to Article 25, which gives us freedom of religion. Article 19(1)(a), this gives us freedom of expression, and Article 21, that gives us the right to dignity, privacy, bodily integrity as well. So these are the questions it is basically raising. So it can be argued that did the court go against these rights which are there or not. However, the larger constitutional issue, it still remains pending before the Supreme Court, because in 2022, in the Karnataka hijab case, the Supreme Court was split whether this should be allowed or not. So there is no decision on it as of now. In future, the decision may come with respect to it. Now, what is the background of the case? So basically, there is a minor Muslim girl, means she is not an adult, she is a teenager, she is in her school, she is a minor Muslim Shia girl. She is studying in Prayagraj school, and she has attended her classes 6th to 10th completely wearing hijab along with the uniform. And now the same thing is what she was doing. Not just that, her photographs, her ID cards also showed her wearing scarf along with the uniform. So it is not that it is a one-time gimmick, or there is a revolt that I want to wear it, how dare you not let me wear it. It's nothing like that. She has been following that throughout. However, now what has happened is the school has not allowed or disallowed her to do so, school subsequently insisted that there needs to be adherence to the prescribed dress code. Now, the student, on the other hand, argued that wearing the scarf was a part of her faith and it is part of her dignity and bodily integrity. She also invoked her freedom of expression under Article 19(1)(a). Subsequent to which, the matter went to the court, and the court said that the past practice is not equal to an enforceable right. Just because you might be wearing it from 6th standard to 10th standard, your ID card, photograph, all those shows that does not make it an enforceable right. Right? So that is the argument that is given. Also, merely allowing the student to wear a scarf for several years, which she has done, it did not create any legal right. It does not create any legal right. Right? You might be having, let's say, you might be doing something which was neglected, ignored, or you were allowed previously. If today someone is invoking certain laws which prohibits you from doing that, they are well within the rights of doing that. Just because you kept on doing it or the school allowed you to do it, that does not make it an enforceable right which the court has said. Okay. So this is the idea. Earlier enforcement could be due to, it might not have been enforced because lethargy, who will enforce it, why to take actions, no inaction, lack of will, or courtesy, or even hesitation to say as to avoid wearing such attire or hijab for that matter. This can be the reason. Okay. Now, the idea is the institution does not permanently bar enforcement of its rules. Right, so it is well within the rights to basically start enforcing now, is what the court is saying, and probably rightly so. So what did the court upheld? The court said the validity of dress code. It said that the school can prescribe a uniform if that uniform is uniform in nature, means same for everyone. It should be same for everyone. It should be in bona fide intention, positive intention, not negative intention. It should not be discriminatory in nature, and it should be done to ensure discipline and institutional purposes. Because of this reason, the institution can, of course, impose a dress code. Further, the High Court mentioned that religious necessity of hijab is not as such established. It said that it basically said that the bare assertion, right, this religious claim that it is given in the religion that we should do it is not the case. Actually, you are simply asserting that, but that is not established as such. Now, I will give you as to what they are talking about. There is a concept of the essential religious practices. Essential religious practices means those practices which are compulsory for a religion or essential for the religion, without the practice of which the religion will not be that religion itself. That is essential religious practice. And the court mentioned that the essential religious practice doctrine was not established in this case, and no evidence was surfaced or given to the court which showcases the fact that wearing a hijab is an essential religious practice. That is what the High Court is invoking. I hope that is clear. Now, for example, if I have to give an example, there are 5 Ks which are compulsory for a Sikh, and one of them is kesh. So growing their hair is compulsory, right? Now, growing hair is not compulsory in any other religion as such. So when they go in the army, the Sikh are allowed to have a beard, whereas a Muslim would be asked to trim or shave their beard. Now, this is not discriminatory in nature. We need to understand this. Why? Because for a Sikh, having a beard is necessary, is an essential religious practice according to their doctrine. Whereas in Islam, it is, if you do, it is good. If you don't do, that is also good. So it's not an essential religious practice. You can say it is preferable to do that, but not essential. So if the army is enforcing any law or which is in place wherein the Muslims or others would be asked to, Muslims specifically would be asked to trim their beard, whereas the Sikh will not be asked to trim their beard, that is not not discriminatory in nature, that is based on the principle of essential religious practices. That understanding we need to have in order to understand that the laws are just and they are trying to create unity in the diverse country that we are. Right? Now, the essential religious practice, as I have already told, there needs to be a constitutional balance between them so that it can balance Article 25, which gives you freedom of conscience, freedom to profess whatever religion you want, but it should be subject to public order, morality, health, and other fundamental rights as well. As far as school uniform is concerned, it is there for institutional discipline, uniformity, and institutional identity. So the institution is well within the rights to ask the students to wear a particular uniform only. However, at a larger level, at a constitutional level, the matter is still sub judice with the Supreme Court. Thank you.